Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Lowell Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Preventing the Revocations of Your Home Health or Hospice Agencies from the Medicare Program, Tips on Avoiding an Adverse Actions and on Responding to Such an Event. Our presenters for today are Jennifer Papapanagiotou and Christin Thompson. Jennifer focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing businesses arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal agreements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers, and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. As for Christin, she's an associate at Lowell Parker. Before joining Lowell Parker, she has worked as a professional coder, assigning diagnosis and protocol codes for urgent care, inpatient, and outpatient facilities. She has experience identifying documentations, deficiencies, and auditing claims for a variety of practice types. Christin assists providers nationwide with developing and implementing policies to improve documentations and coding practices. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box and we'll address as many as possible at the end of the presentation. So without further ado, I present to you your speakers, Jennifer Papapanagiotou and Christin Thompson.
Hi, everybody. This is Jennifer Papapanagiotou. My colleague, Christin, is going to be listening in with us today and may have a few comments here or there, but she is losing her voice. So I'm going to try to blaze through this and cover a pretty comprehensive overview of adverse actions and revocation authorities. So let's go to the next slide, Gio. All right. So briefly, we're going to talk about the 22 current revocation reasons, what we see most commonly, and the fastest way to lose a Medicare number based on our current experience. I've been doing this and working in this area for 20 plus years. It really got intense around 2010 when they implemented a host of the new screening and screening requirements for enrollment and revocation authorities, and those were significantly expanded right at the time COVID started, so effective in 2022. So we've just seen a tremendous uptick in activity. We're also going to give you tips on how to avoid these things. And then if the worst were to happen, we're going to cover the appeal process and a little bit about the new provisions on stays of enrollment. Let's go to the next slide. The one thing we're not covering today is survey and certification. We're not going to talk about surveys. We're not going to talk about the enforcement process for surveys. That's outside the scope of what we're going to discuss. So there are 22 revocation reasons. These are found at 42 CFR 424.535A. They're reiterated and elaborated on in the Medicare Program Integrity Manual, specifically in Chapter 10. If you ever really want some lovely reading material that will put you right to sleep, you can find the Program Integrity Manual on the CMS website. I've folded and read the ones we see most often. This has changed over time. Currently, we are still seeing revocations based on felony convictions. There is an absolute obligation to report any felony conviction on your enrollment application, and that applies to the provider entity. Yes, entities can be convicted of felonies. It also applies to owners and managing employees and anyone else that is disclosed on your enrollment application in either Section 5 or Section 6 of either the paper 855A or the PACOS application online. If CMS determines that felony is detrimental to the Medicare program or its beneficiaries, then they can revoke an entity based on that conviction. False or misleading information on an application is another very common revocation reason, and this usually comes up when someone fails to disclose an adverse action for the entity or for its owners or managing employees, again, that appear in Section 5 or Section 6. If you leave out information that is responsive to one of the questions, specifically usually in the disclosures of the adverse action sections, which show up in Section 3 of the application and again in Sections 5 and 6, if you leave something out, either because you don't realize it's supposed to be disclosed or you decide maybe you don't think it meets the definition of what's disclosable, that's the same as a false statement under their particular rules. There's no intent necessary to violate this particular revocation reason. If you leave it out and it should have been disclosed, that's enough. Let's go to the next slide. Abuse of billing privileges is probably one of the most active revocation reasons we are seeing right now. There are two parts to this rule. It started out years and years ago with just the first part, which was what we called impossible claims. That was billing for deceased beneficiaries or billing services for a provider who, for example, wasn't in the country, and they could actually track that through things like travel records. That happens much less frequency than the second part of this, and that is what is called a pattern or practice of billing errors. We're going to talk a little bit more about this on a later slide, but suffice to say, this is one of the most popular revocation reasons we're seeing right now. Number 9, failure to report changes has always been a really common revocation reason. This is usually, but not always, usually related to either failing to report an adverse action or failing to report a change in location. And we'll talk a little bit about that as well later on. Let's go to the next slide. The last one I've highlighted here is an affiliation that poses an undue risk. We will talk about this a little bit more later on when I talk about one of the specific sort of high-risk revocation areas, but I wanted to give you a little bit more understanding of what does that mean? What is an affiliation that poses an undue risk? Revocations based on affiliations that pose an undue risk are happening it's been more active in certain Medicare administrative contractor jurisdictions, and specifically in California, which is covered by NGS. CMS implemented this revocation authority in 2020, and it was implemented in an effort to find and kick out entities that were affiliated with other businesses that had what they called disclosable events. And those are all defined terms. Affiliation is a defined term, and disclosable event is a defined term. The relevant regulations are in the same section as the revocation authorities. So it's in 424.519. That's where it talks about the obligation for providers to disclose affiliations, which through instructions from CMS, we actually don't have to do yet because we don't have a way to do it yet on the provider enrollment applications, but you are required to disclose upon request by a contractor. And that reg also talks about disclosable events and what they are. There's a definition actually found in another regulation, 424.502, for some of these key terms. That definition section gives you a specific definition of affiliation and disclosable event. And I'm going to cover those real briefly. So an affiliation, for purposes of this revocation reason, is any of the following. It is a 5% or greater direct or indirect ownership interest in an individual or entity that you are required to disclose on your enrollment application has in another organization. So if you're an owner of a home health agency and you own another home health or hospice agency or any other healthcare provider that's enrolled in the Medicare program, and those ownership interests are 5% or more, that's an affiliation. And depending on circumstances, that affiliation might have to be disclosed or could pose a risk of revocation depending on certain factors. The other affiliation categories are general or limited partnership interests in another organization. They include operational or managerial control over or direct or indirect control over day-to-day operations of another organization. So if you're an administrator of one home health agency and you're also the administrator or clinical director or alternate administrator of another home health agency, that's an affiliation. It also includes officers and directors of other entities. So if you have, let's say, a president or vice president or CEO of your home health agency who also serves in similar role in another enrolled home health hospice, any other kind of other Medicare provider, or perhaps they have an ownership interest in another provider, that's considered an affiliation. And then finally includes reassignment relationships, which generally only apply to physicians and other mid-level providers. But if you have, for example, a medical director, and he is also employed by a physician group, he has a reassignment relationship generally with that physician group, and that can be an affiliation that falls within this definition if he also works for your organization, let's say as a medical director. So the existence of an affiliation all by itself is not necessarily problematic unless that affiliated provider has a disclosable event. And disclosable event is also a defined term, and there are very specific categories that we worry about. We worry about current uncollected debts to Medicare, Medicaid, or CHIP. We worry about a payment suspension that happened at any time in the history of that affiliated provider. We worry about exclusions that ever happened at any time and regardless of their status with that affiliated provider. And we worry about revocation or termination of Medicare, Medicaid, or CHIP billing privileges with that affiliated provider. So I'll give you an example. You have a medical director who serves for your organization. He is also, let's say, a medical director at another hospice agency. If that other hospice agency gets revoked by the Medicare program and your medical director worked over there at some point, that could affect your business and your relationship with that medical director because he would then have an affiliation with an entity that had a disclosable event. And that could become a problem for your agency. We've actually seen this happen. And Christin has some examples from work she's doing right now on these affiliation revocations where we've actually seen this play out in specifically with medical directors. I've also seen it play out with owners where you've got owners that have multiple businesses and one of them gets crossways with Medicare, gets revoked, and they turn around and revoke the other businesses that that owner owns. Just having an affiliation with a disclosable event is not enough. If that exists, Medicare is going to assess whether there's an undue risk to the program of that affiliation. And they look at a series of factors, but this is ultimately a discretionary decision by CMS. They look at how long the affiliation existed, whether it still exists, and if not, how long ago did it end? They look at the degree and extent of the affiliation. They look at why the affiliation ended, if it has terminated. And then they look at the disclosable event and all the factors and what kind of disclosable event was it. And then, of course, the catch-all, any other evidence they think is relevant to their determination. As you can see, anything that's factor-driven and that CMS has discretion whether to take an action or not is really difficult for the provider community to overturn on appeal. The administrative courts and authorities that handle revocation appeals generally tend to give deference to CMS, and so we have some information later on here on how to avoid this ever becoming an issue, but should it become an issue, we've also got some advice on how to approach it. Let's go to the next slide. So I kind of loosely put risk areas into three categories for revocation: enrollment problems, operational problems, and billing problems. We're going to cover all three. Enrollment problems can be anything from something like failing to report a change of location, failing to revalidate on time, failing to report an adverse legal action, or failing to report, say, owners or managing employees with felonies. Operational problems generally have to do with something like a failed site visit where they came to visit your location and couldn't find you because either you didn't have good signage or you were closed during your posted hours of operation when they came to do that site visit. It also includes things like employing excluded persons or affiliations. Your owners, managing employees, officers, directors, medical directors having affiliations with entities that have disclosable events. And those are screening issues that we'll give you some tips and tricks on how to address that and avoid that later on. And the third category, these billing problems, this is really that revocation reason for pattern or practice of billing errors. So if you've repeated high error rate claim audits, and in some cases, not really repeated instances of high error rate claim audits, we've seen some based on a single audit, and those are specifically related to what's called the period of enhanced oversight reviews, which thankfully are not relevant to people in Louisiana right now. They are only being conducted in a limited set of jurisdictions right now: California, Arizona, Nevada, and Texas. They have not expanded the program, and let's all cross our fingers that they never do, because they are brutal. Let's go to the next slide. And we're talking a little bit about enrollment. So those, I kind of cross-referenced these common revocation reasons with my original 22 potential ways you can get revoked. But essentially, the most common ones we see: owners or managing employees with felonies in the previous 10 years that you've either failed to report or failed to remove, usually. Responsive information that got left off an application. This almost always has to do with adverse actions. And failing to report a change of location, or failing to remove a deceased owner or managing employee. I've handled a bunch of those recently for whatever reason. But you should know, if an owner of your organization or managing employee who's reported on your enrollment application passes away, you have an obligation to remove them from that record. They will, you can do it affirmatively once it happens, but they will also send you letters reminding you to do it as soon as Medicare receives notice from the Social Security Administration that somebody in their database has passed away. So how do you keep something like that from resulting in a revocation? Well, you keep your enrollment record up to date. And I've listed just a few little things that we over the years have learned. So I actually had a revocation once based on an application where the provider had listed a commercial mail service as its practice location. That's usually not relevant for home health, but it can be relevant in certain circumstances for things like physicians who work primarily in facilities. That was the case I handled. So obviously never ever use a commercial mail service in Section 4 where you report your practice location. You can use those for correspondence addresses, but you cannot use them as a practice location. You need to understand and know your enrollment obligations. And I've got a few slides here that we'll cover that talk about those. Absolutely always keep copies of everything you ever submit to Palmetto. And I mean, if you send a paper application, you need to keep a copy of the signed version of that application that you sent. If you submit that application by PACOS, you need to print out what you, or PDF, and save exactly what you submitted along with your submission confirmation. If you send a paper application, use trackable mail so that you can prove it got there. Palmetto loses stuff all the time. And if you have a revocation, let's say based on failure to report a change of location because the site inspector came out and couldn't find you, but you can prove you sent them an application and you got a copy of it and you can show it was delivered and it was delivered before that site visit happened, I can actually fix that. I can't fix it if I can't prove you ever delivered an application in advance of when that site visit happened. So those are just a few of our sort of good practices when it comes to maintaining your enrollment record. Let's go to the next slide. The enrollment regulations are actually primarily found in 42 CFR 424.510. It's absolutely critical that you fill your applications out truthfully and completely. Whoever signs that application, who's called the authorized representative, attests that the information is accurate and that you're going to abide by all applicable statutes, regulations, and program instructions. Leaving information off applications, especially adverse actions, is probably the most common way I see revocations happen related to sort of these enrollment obligations. The other is not reporting things timely. Only an authorized rep can sign an application, and that is defined in Medicare's regs as an individual who has the authority to bind the provider or supplier both legally and financially to the requirements set forth in this chapter. They are looking for an owner or an executive. And when I say owner, I mean a direct owner. So if you don't have individuals who are direct owners of your entity, let's say there's a holding company maybe above your provider entity, you're going to have someone who's been appointed, say, president or CEO of the provider entity. They're an executive, they meet that definition. They have to be reported in Section 6 in that role, and then they're an authorized rep who can sign an application. If you happen to use an outside credentialing person to prepare applications, there's nothing wrong with that practice. PACOS has been set up to allow you to appoint things like staff end users who can prepare applications on behalf of a provider. That's fine, but protect yourself. Be sure that the authorized representative reviews the application and that it's accurate, and that you communicate with whoever is working on that application to make changes if you think changes are necessary. I absolutely caution you against letting anyone sign an application for you. If you're using PACOS, they actually track IP addresses, and they can theoretically know if you're physically residing in Louisiana, but somebody in California with an IP address in California signed that application. They can question that. I've never seen it happen, but they say they can do that. The real important part here is if you're the authorized rep and you're signing an application, you're responsible for everything in it. And you shouldn't be delegating that responsibility to anybody else. I can't tell you the number of times I've had to talk to somebody who said, well, my credentialer filled this out and they left information off that should have been there, and I didn't know. Well, that's on you. That's not on them. You may have a legal action against somebody you gave all the right information to who didn't do it accurately, but Medicare's not going to care about that. They're only going to look at, hey, authorized rep, you didn't do it, your entity is revoked. So just a word of caution. Let's go to the next slide. Okay. Once you're enrolled, which generally speaking, everybody who's listening today is already part of an enrolled entity, what are your obligations to report changes? Well, this is a handy dandy slide you could print out, tack up on a board above your desk. Changes of ownership have to be reported within 30 days. Changes of ownership have a very specific definition under Medicare's rules, and generally it means an asset sale of the business to a new legal owner who has a new tax ID number. There are a couple of other categories, but that's the big one. Change of control, those have to be reported in 30 days, primarily because they also result in changes of authorized or delegated representatives, all of which have to be reported in 30 days. Changes of control generally are those equity sales where somebody comes in and buys all the shares or membership interest in your entity, and at the end of the transaction, they own and control your entity and take your tax ID number along with it. They own your business, altogether. Those are the two sort of the differences between change of ownership and change of control. The reality, though, is both have 30-day timelines to report that to Medicare. Final adverse legal actions, you have 30 days to report license revocations or suspensions. Otherwise, you have 90 days to report them. Final adverse legal actions include things like felonies. They include things like suspensions. They include things like terminations by Medicaid. I will tell you, reporting a final adverse legal action carries a whole bunch of risk with it, and it's really, really important you talk to your counsel before you do it, because you may want to take a different path, meaning it's not always the case, but it's often the case that if you find yourself in a situation where you have to report a final adverse legal action, it's going to get you revoked if it's not something that's curable. And the better path may be to voluntarily terminate rather than report a final adverse legal action. So for those, I really recommend you talk to a healthcare counsel and let them help guide you through that. If you're changing, adding, or deleting a practice location, you now have 30 days to report that. It used to be 90 days. They shortened it to 30 days. Any other change to any other section of the CMS 55 enrollment application is supposed to be reported within 90 days. People always ask me, if I don't meet this deadline, is something terrible going to happen? And my response to you is probably not. My advice to folks is, if you've missed the deadline, you got to just do it. They have been instructed at the contractors to accept a late filed application, and they're not going to do anything about that unless there's already a revocation action in process. So 99.9% of the time, it's not going to be a problem if you report something late, but you still have to do it. Let's go to the next slide. Revalidation, everybody's probably familiar with revalidation because I think most people that have been in the program for more than 5 years have probably been through or going through revalidation. But the requirements at 424.515 require all providers to revalidate at a minimum every 5 years. You can also be asked to revalidate off cycle, and you still have to do it if they ask you to do it. If you miss your revalidation deadline, that can result in a payment hold, a stay of enrollment, or a deactivation. It generally does not result in revocation, and that's a really important difference. You can check yourself whether you're due for revalidation. I put the website up here. That's updated every 2 months, and they've generally been really good at keeping to that schedule. If you are due for revalidation within 6 months, your organization will appear on the revalidation database list. Once you see yourself on that list, you can submit your revalidation. If you send it before that, they probably won't return it to you as being untimely. If you haven't completed revalidation yet and you're within the 6-month window, you'll likely get an email or letter 2 to 3 months before the due date to remind you. It's really important that your correspondence addresses and your email contact addresses are up to date in your enrollment record so that you get these notices. There is a fee to revalidate. It's $730 this year. It does change every year, goes up every year. PACOS, if you do an online application, will prompt you to pay that fee before you submit the application. If you're sending a paper application, I've given you the website where you can go and pay the fee, and it'll print out a receipt essentially for that, which you need to print and send with your application. If you miss your revalidation deadline, don't freak out. It happens. Send the application as soon as possible. Sometimes you get a little grace and nothing happens. Depends on how late it is. Sometimes you get deactivated, but the day you deliver that revalidation application will be the effective date you get back into the program and become active again. Sometimes there's a gap in your billing privilege effective dates between when you're deactivated and when you're reactivated. If you find yourself in that situation, I highly recommend you reach out to Healthcare Council and see if they can help you. We have appealed those reactivation dates upon when you've missed a deadline, for example, and there's some gap. And sometimes, depending on the circumstances, we are able to convince CMS to eliminate the gap. But there's a whole process for that, and we're going to talk a little bit later about the appeal process. Let's go to the next slide. So I'm kind of reiterating some tips for enrollment work that I talked about a little bit earlier. If you send a paper app, use trackable mail and print your proof of delivery, keep a copy of everything. Palmetto has a physical address where you can have a FedEx or a UPS delivered on their website. I highly recommend you use it. I don't like US Postal Service. They lose crap all the time. FedEx and UPS have historically been a little more reliable. You can use the US mail. If you're going to certified mail, priority mail or express mail are the standard trackable ways to send mail by USPS. If you use PACOS, which is the CMS online enrollment system, save your PACOS submission confirmation and save a copy of what you submit. The contact persons who are in Section 13 on your PACOS application should all receive confirmation emails when an application is submitted. If you don't get one and you're a contact person on the application, something went wrong. And you need to reach out to the PACOS help desk. The phone number's on the first page of the PACOS website, and see if they can help you figure out what happened. It may be that you didn't hit the right combination of buttons. You maybe go back in and resubmit it, but reach out to the help desk, and they can often help walk you through figuring out what happened. Keep copies of your applications, as I said, whether it's PACOS apps or it's a paper app, and all the attachments that you send along with that application. This is especially important if you're disclosing like adverse actions, because oftentimes those require explanation and they expect you to attach certain things. So I caution people, just be really complete. When you make a copy of something you submit, make sure you include all those attachments as well. If you're responding back to a development request on an application, so you sent it in and Palmetto sent you a letter and said, hey, we need you to change this and provide us with another attachment for this, keep copies of that as well. keep copies of proof that you submitted it. If you faxed it, keep your fax confirmation. If you emailed it, put email tracking on it so you get a delivery confirmation. All of these are in an effort to protect yourself should something not end up where it's supposed to and something bad happens later on. And as I said earlier, if you miss a deadline, send the application anyway, and in most cases, you're going to be okay. Let's go to the next slide. Lastly, I just want to touch on felonies again. People are often asking me questions about what's reportable and what's not reportable, and is something bad going to happen? CMS is really strict about reporting felony convictions in the previous 10 years from the date you submit that application. And it applies to owners, managing employees, officers, and directors of your organization, as well as medical directors now, because, well, it was at least for hospice, and administrators, because you're required to report the administrator on a home health enrollment. And on a hospice enrollment, you're required to report the administrator and the medical director. Any felony, it says within the previous 3 years, that should say within the previous 10 years, apologies, is reportable as an adverse action on the CMS 855A, regardless of the type of felony. If you go read the regulation for revocations, there are really 4 types of felonies that CMS is really concerned about. But I want to be really clear that any felony, even if it doesn't fall into one of these 4 categories, is still reportable. It just may not result in something bad happening like a revocation. CMS ultimately has discretion to determine if a felony is, quote, detrimental to the best interest of the Medicare program and its beneficiaries. They have identified these 4 categories that are essentially per se detrimental. So if it falls into one of these categories, that's bad. You need to talk to counsel before you report it, and you should be identifying and screening for these before you bring on folks that fall into one of these reportable roles. So felony crimes against persons like murder, assault, rape, felony financial crimes, that includes income tax evasion, insurance fraud, embezzlement. Most of the healthcare fraud crimes fall into this category. Any felony that placed the Medicare program or its beneficiaries at immediate risk, things like criminal neglect or misconduct, and any felony that will result in mandatory exclusion under the Office of Inspector General's exclusion authorities. That generally includes the 3 bullets above here, as well as the unlawful manufacture, distribution, prescription, or dispensing of a controlled substance. If an owner, managing employee, officer, or director, and I would add to that, administrator or medical director, has a felony conviction in the last 10 years, it's likely that you have to remove them from your organization and your Medicare enrollment record. I would caution you to visit with your healthcare counsel to confirm that, but it is likely they should be removed. If you have not found yourself revoked yet, you do it preemptively, you keep documentation of it. If you have received a revocation letter based on a felony conviction for one of these individuals, you have essentially 15 days to show you fixed it. And generally speaking, CMS will rescind the revocation. Not always, we don't have great regulatory support for that, unfortunately, where we do have that for excluded individuals. But we have found in the past that if you quickly act to remove people with felony convictions, oftentimes we can get you out of a mess with CMS. Let's go to the next slide. Okay, the second category of how to get revoked include things like operational issues. I had mentioned earlier, failed site visits are generally the most common way. There's also 2 others that I'm going to touch on here. That's employing excluded or debarred persons, and we're going to talk about affiliations a little bit more. So on-site review, other reliable evidence the requirements are not met. That's one of the revocation reasons. It's usually because they couldn't find you when they tried to do a site visit. You didn't have good signage. You're in an office building with multiple offices, and for whatever reason, they couldn't find you. Or they came by to the correct location, but it was closed during your posted hours of operation. The other big operational issue we find has largely to do with your hiring practices and your policies and procedures for that. And you somehow ended up employing someone who was excluded or debarred in one of the key roles: owner, managing employee, authorized or delegated official, medical director, supervising physician, or quote, other healthcare personnel. If any of these people or entities are debarred, suspended, or otherwise excluded from federal procurement or non-procurement programs or activities, then they can get you revoked. federal procurement or non-procurement programs, there's two main federal websites where this information is posted: the HHS Office of Inspector General, LEIE, and the SAM list, which I believe is posted by the General Services Administration. Let's go to the next slide. So how would we avoid or prevent a revocation for something like a failed site visit? Like, how are we not going to have that problem? Well, state licensing and federal Medicare regulations require home health and hospices to have signage and post hours of operation and emergency contact numbers on the outside of their business. And it needs to be, on the front door essentially, or by the front door. If you're well, marked by signage and you've got the right information on the sign, great. You've already ticked off one of the things that can go wrong. The other is you got to be open during posted hours. So you got to treat your office like a retail business. If you're supposed to be open from 9 a.m. to 5 p.m., then you have to be open to receive patients during those hours, and also surveyors. And you can't decide that, I'm sorry, I'm going on vacation for a week and I'm not going to be around, and so I'm just going to put closed and then I'll be back in a week. You absolutely can't do that. And I have a cheeky little comment: you wouldn't close down the local hospital so everyone could run an errand or go to lunch. If you have to leave or you close for a regular lunch hour, you need to post a sign and say, out from noon to 1, please contact this phone number in an emergency. Surveyors or site visit inspectors will tolerate that, but they will not tolerate, I'm gone for a week. You have to plan for any kind of planned absences or emergencies so that your office is open during your posted hours. If your regular receptionist, who's supposed to be there every day to open and close the office, is sick and can't come to work, who's going to cover? I don't see this as much as I used to. I think folks understand it and appreciate it, but I had a whole bunch of these years, between 2010 and like 2018, I had a whole bunch of these for whatever reason. The site inspectors will make at least 2 attempts to find you and confirm you're open for business. And they don't come inside. They don't talk to anybody necessarily. It's not required that they do that. If they come to a location and for whatever reason they're having an issue, oftentimes they will call the emergency contact phone number and try to reach somebody. So you need to be sure you're monitoring that emergency contact number and returning messages timely. Whoever monitors that emergency number needs to know, to what to listen for and who to refer it to. So it's important someone gets to those and gets to them very timely. All right, let's go to the next slide. So what about excluded persons? Well, if your agency gets revoked based on an excluded individual, you need to remove that person immediately. And if you deliver proof to CMS within 15 days after you get your revocation notice, that's a corrective action that there's actually a regulation that says they will rescind the revocation. So it's really important that you move really quickly. You can't only check the mail once a week, guys. If your mail goes to a post office box, you gotta have somebody checking that more often than that. You don't wanna lose time when you get sort of these important communications or could receive these important communications from Medicare. It's likely they're not gonna email this letter to you. They're gonna send it by regular mail. So it's something, unfortunately, I have seen situations where, I was on vacation and I didn't check mail for a couple of weeks, and then I came home and I found this letter, and I'm like, well, yeah, somebody needs to be checking that mail. To prevent situations like an exclusion based on one of your owner's managing employees being an excluded person, you absolutely have to have standardized hiring procedures that screen for this kind of thing. You don't just screen for exclusions, but we're going to talk about affiliations in a minute, but there are obviously publicly accessible websites where you can do this screening on a regular basis. Our recommendation is that you do it before someone begins work and that you then do it monthly thereafter. That's what OIG recommends. There are certain state programs, Medicaid programs, and I can speak to Texas because I'm in Texas. Texas requires monthly screening if you're a Medicaid participant. So Our recommendation is that you follow the conservative guidance and you screen everybody in your organization monthly. Everybody that ever touches the patient payment cycle or renders clinical care to anybody needs to be screened for exclusion. If you use staffing agencies and you, for example, if you contract with another staffing agency for therapists, you can pass along the obligation to do that screening in your contract with the staffing agency and expect them to do it for you. But they need to be obligated to provide you proof of that upon request. And I draft contracts with staffing companies all the time for my clients, and this is something that's important that we stress. You can also do it yourself as the home health agency if you've got the information to do that. Maybe you work with a specific, several specific independent staffing agencies and certain specific individuals over and over again. But it's really important that if you delegate it, that you have the ability to request proof of it. And I recommend to people that you test the system. If you're bringing on, and they're going to assign a new therapist to you from a staffing company, okay, great, send me over their credentialing file. I want to see a copy of it. That's just good practice. Obviously, if you're going through a transactional process and you're buying someone else's business, I do a lot of that kind of work. I highly recommend that you screen all of the staff that you're going to be bringing over before you do that acquisition, or literally day one, so that you can confirm there aren't any excluded persons. There are outside contractors that will do this for you. They're great at automating the process and making it easier for you. And I think they've become more cost effective over the years. Again, if you identify an excluded, debarred, or suspended person, that can have an overpayment impact. There can be an obligation to refund some monies. We highly recommend you consult legal counsel. There is a self-disclosure process for that to the OIG. We've taken folks through that several times. These are the things you want to do to avoid ever getting to a revocation. Let's go to the next slide. I want to touch on affiliation revocations while we're doing this. I kind of explained what they mean earlier. Much like screening for exclusions, you should be screening for affiliations with entities that have disclosable events. And generally what this means is you're going to do it very similarly to how you do exclusion screening. You're going to screen before you hire and regularly thereafter. My suggestion is at least quarterly. Standard for your screening obligation is that you knew or should reasonably have known that one of your owner's managing employees, medical director, officer director, or management staff had an affiliation with a disclosable event. So you knew or should reasonably have known. You've got to ask questions and you need to be documenting their responses to it. My suggestion is you develop a screening tool with relevant questions. I've done that for a few clients to help them basically, add that to their onboarding packet. And then as part of their either coffee process or as part of sort of their management meetings, they go back through those on a regular basis to have people reattest to their answers. Unfortunately, there are no public resources where you can check for uncollected overpayments or payment suspensions. That is entirely relying on what people know or don't know about someplace they used to be affiliated with, probably, or may still be affiliated with. Your obligation is that you should ask the questions and get responses in writing. We don't have great guidance from CMS on how they're interpreting this new or should reasonably have known standard. So for now, we're trying to develop sort of best practices. And my advice to clients is have a standardized screening tool that everybody fills out. And for those you can't cross-check anywhere, you're going to have to a certain extent, rely on the person who's making the disclosure to you being truthful. But I think I can protect you if a revocation were to happen based on affiliation, if you can show you did at least that level of diligence. You can screen for enrollment status. You can tell if a physician, a home health or hospice agency, meaning one of those affiliated providers, is in the Medicare program or not using these websites that I've provided to you, but you can't, it doesn't tell you why they may not be in a program. It just tells you if they're actively enrolled or not actively enrolled. That can kind of spur a conversation that might you might ask more questions about that affiliation, but again, it's not a reliable source for was someone revoked or was someone suspended and ultimately kicked out of the program. You can obviously screen for exclusions, which is one of the other disclosable events. Keep in mind, remember, the disclosable events are uncollected overpayments, payment suspensions, revocations, and exclusions. So really, this is about standardizing and adding this to your existing hiring practices. And again, if you identify an affiliation that has a disclosable event, then we recommend terminating or divesting that person. Contact your healthcare counsel for advice on how to go about that and what to do if, for example, you receive a revocation letter. We have some of these ongoing right now where we've, terminated or had the person divest within that 15-day window we talked about for taking action if you're notified you've got an excluded person and you've been revoked. We're taking the approach that if we get rid of them within 15 days and we notify CMS of that, we are actively pursuing appeals where we've done that, and we're hoping CMS will agree with us that that was the right thing to do, and they will ultimately rescind the revocation. Unfortunately, we don't have a regulatory provision that says they have to reinstate the entity, but this is the approach we're going to take for now until CMS gives us more clear guidance on it. Let's go to the next slide. All right. Abusive billing privileges, probably one of the most active revocation reasons we're seeing right now. CMS has discretion to determine if a provider has a pattern or practice of billing errors using 4 factors. It used to be a longer list of factors. They shortened it in 2022 to make it easier for them to revoke based on this reason. They actually say that in the Federal Register notice that implemented this rule. So these are the factors: the percentage of claims denied during the period under consideration. And I warn you in advance, that can be a single small audit. We're seeing that a lot in California and not as much in other jurisdictions, but NGS has really been using this a lot. They'll look at the provider's history of final adverse actions and the nature of those actions. They'll look at the type of billing noncompliance and the specific facts surrounding that noncompliance. And then, of course, the catch-all, any other information they think is relevant to the determination. The reality is these pattern or practice of billing error cases are really difficult. They're driven a lot by data mining and audit activity by the MACs and UPICs. You're often put in a position, if you're revoked on this basis, of pursuing both a claim appeal and a revocation appeal through 2 different appeal authorities. And unfortunately, there are no stays of revocation. So when you're revoked, if you file an appeal, it doesn't stay the revocation. The revocation is going to stay in place the whole time you're appealing it. So most clients that rely heavily on Medicare revenue are going to be out of business. They're not going to have any revenue while you're trying to fight both appeals. These can be really, really difficult. I just put a few examples here of cases that we've worked on. A hospice that was suspended based on a credible allegation of fraud, which was based on a review of 5 claims, and then they were revoked. We've had a number where there have been repeated UPIC audits. Usually it's 3 in a row over a period of several years with high error rates. And I've had 2 or 3 of those in the not too distant past where the error rates were usually pretty high, over 80%, that led to revocation. And then we're working on a number of cases that involve the provisional period of enhanced oversight audits, which are happening in 4 states right now. I mentioned earlier, California, Nevada, Arizona, and Texas. Those happen after a change of ownership or 100% change in shareholders or members. And we are seeing a tremendous amount of revocation activity based on those audits. Those are generally really small audits. They could be as few as 8 or 9 or 10 claims. And if there's a high error rate, and then I mean like not even all that high, frankly. I mean, I see, audits with 50% error rates all the time. We have multiple examples where we've had, a 50% error rate on a PPEO audit that only involved 8 claims and the provider was revoked in California. It's truly distressing. We're appealing those. We're hopeful that CMS is going to acknowledge that NGS is overreaching in those cases, that they're being too restrictive. We just aren't deep enough into the appeal process at this point because these are fairly new to really have a feel for what CMS is going to do in those cases. So stay tuned. We'll give updates in later presentations as we learn more about it. Fortunately, this isn't an issue right now for Louisiana. You're not subject to these provisional period of enhanced oversight reviews. But I will say we are seeing a tremendous uptick in the number of SMRC audits. Those are usually medical review audits, and they're conducted by Noridian. I'm not necessarily seeing revocations tied to those, but you've also got TPE audits going on. Obviously, UPICs always have the authority to do audits. So our biggest piece of advice, if you're subject to audit and you have any claims denied, if there's any chance that you could appeal it and be successful, we absolutely say you must appeal it, even if these are not high dollar issues. It's the problem with this pattern or practice of billing errors is the value of the claims denied is irrelevant, frankly. It's really about the percentage of claims denied, and even if it ultimately does end up in a big overpayment for you, you could still run the risk of revocation for claim audits where you
Hey, Jennifer, you're cutting off a little bit, or I think you cut off completely.
putting warning language in those that you could be referred for further action. They're also putting warning language in UPIC audit result letters that basically says, you know, under our authority, under the revocation rules, under certain conditions, we could revoke you for a pattern or practice of billing errors. And so sort of like teeing up the fact that if you have high error rates in audits, you could be revoked. Let's go to the next slide if we can. And let's go to the next one after that, please. All right, billing issues. How do we prevent these? Well, if there's a claim error and you learn about it, you fix it. If you don't have that opportunity or it's discovered later on, there can be ways to go about making either self-reports and refunds. And oftentimes we've been able to convince them to reopen and let us correct claims past the year. If you must have a compliance program suitable to your business that includes regular claim auditing. QAPI programs often include reviewing a certain number of claims during, you know, quarterly QAPI reviews. That's really, really important, and you need to pay a lot of attention to that process and learn from it. Know your denial of reasons and work to reduce their frequency, and you absolutely have to take what you learn, for example, from those QAPI program reviews of claims, and educate your staff about how to improve their documentation, because generally speaking, a lot of what we see are denials will be based on insufficient documentation. And sometimes they're technical and sometimes they're substantive. Sometimes you just didn't do a great job of documenting medical necessity or supporting homebound status, and I know oftentimes we're relying on third parties to provide sufficient narrative. So sometimes it could be that your referring providers need to be educated. There's you know, a whole spectrum of how to provide feedback, and we often coach clients through that process. And as I said before, appeal denials, even low dollar overpayments, can become revocations if they happen repeatedly. Let's go to the next slide. I know we're kind of running short on time, but we're going to talk a little bit about the revocation appeal process. If you receive a revocation letter, so what's all the bad stuff that can happen? Well, you got to look at the effective date. It depends on the revocation reason what that effective date is going to be. In most cases, it's going to be 30 days from the date you got the letter. But there are certain circumstances where it can actually be before you got the letter. Felony convictions will be the date of conviction. Site visits will be the date of the last failed site visit attempt. Excluded individual revocations will be the date the person or entity was excluded. Virtually all the rest are going to be 30 days from the date you receive the revocation letter. You will not get paid by Medicare after the revocation effective date. And if it's retroactive, CMS and the contractors are going to ask you become reportable to other payers and authorities. For example, Medicaid. Medicaid has an absolute regulatory obligation to terminate you if you're revoked by the Medicare program. Private payer contracts often have reporting obligations for revocations, and if you're accredited, it's reportable to your accrediting body as well. My advice to you is contact healthcare counsel and let them help you game plan how to best do this. Let's go to the next slide.
Hey,
So
Jennifer,
what can
you double check your mic. You cut off twice.
oh,
on
okay.
that slide before you said there's provider suppliers won't get paid if Medicare and Medicaid.
Okay. So just to quickly review then, there's no stays in revocation cases. So you're going to be revoked and not receiving payment the entire time you're revoked. And either until you're reinstated because you win an appeal, or until your re-enrollment bar runs out. And re-enrollment bars are imposed by CMS. They're from a year to 10 years in length, and it usually depends on the revocation reason. If you're revoked, you're going to have reporting obligation to other payers. For example, you're going to have to report to Medicaid. If you're a Medicaid provider, you're likely going to have to report to private payers if you have private payer contracts, and it will be reportable to your accrediting body if you're accredited. Let's go to the next slide. Okay, so what can you do to try to manage a situation like this? Well, immediately get with your healthcare counsel, talk about appealing and alternative business arrangements or workarounds that might help you stay in business. My biggest piece of advice is do not try to do this yourself. You need legal counsel. This is your whole business on the line, and you have strict deadlines for when to act. You'll have 60 days to file a reconsideration appeal for that revocation. And in some cases, depending on the revocation reason, you may have an opportunity to file what's called a corrective action plan. Your attorney is going to need as much time as possible to prepare those and gather all the relevant evidence. So you need to get with them quickly. If it involves an excluded, suspended, or debarred person, and I would add to this people with felony convictions and affiliation revocations, within that 15 days after you receive notice, remove that individual and submit proof they were removed. That can often, and in the case of exclusions or debarments, it will get you reinstated. Consider reducing your Medicare census and transferring patients to other providers. You have to kind of review your private payer contracts and figure out whether you're going to be able to keep those patients. Sometimes that requires some game planning with your counsel about how to handle it. You need to think about a way to address staffing and whether you're going to have to reduce staff, but retain necessary personnel while you're transitioning patients to new providers. And you've got to conduct a realistic financial analysis of how long you can stay in business while you're fighting one of these actions. It really is very fact dependent on what's the revocation reason and what your arguments are to support getting something reversed. And then healthcare counsel can help guide you through the process and give you some advice on, how long is this going to be and how much is it going to cost? Let's go to the next slide. I don't want to review this in a whole lot of detail other than to say the appeal procedures are outlined in both regulations and in the Program Integrity Manual, Chapter 10 that I mentioned earlier. Corrective action plans are only available for what we call reason 1 cases, which is kind of a catch-all revocation reason for stuff that doesn't fit within any other revocation reason, but it's usually related to licensure. It's optional. You have 30 days after you receive a revocation letter to take advantage of corrective action plans, but they are completely voluntary and is not a required step in any appeal. Reconsideration is the first mandatory level of appeal if you choose to pursue it. You have 60 days from the date you receive notice to file that. Even if you file the cap, you still have to file the reconsideration, whether you've received a decision on that cap or not. The important thing to know about a reconsideration is it is an evidentiary milestone. Every piece of paper, every documentary piece of evidence you ever want considered has to be submitted at this level of appeal. There's only very narrow reasons and ways to get documents in after this level of appeal, and it generally has to be something that was unavailable when you filed your reconsideration. These are generally filed with CMS's appeals group within the PEOG department, which is their provider enrollment and oversight group. Usually you get an answer within 90 days of filing. We've seen some taking a lot longer than that of late, especially with the change in administration. We also know that the person who was the head of the appeals group left, and there's an interim person right now. So things are a little wonky with CMS's appeal timeline right now, but generally they don't have a regulatory responsibility to reply within 90 days. That's guidance that they follow, but in the past, they've usually met those deadlines. And you have to make all your factual and legal arguments in that reconsideration request and address all the revocation reasons. So if there's more than one, you have to address them all, and you have to overturn them all in order to win. So let's go to the next slide. If you lose at reconsideration, there's another level of appeal. There's actually 3 more levels above that. There's something called the Departmental Appeals Board, and there's a Civil Remedies Division, and then there's an appellate body within that above the Civil Remedies Division that you could further appeal to. This is administrative litigation with rules of procedure and briefing schedules and orders, and there's an administrative law judge that will be assigned your case. You have to file your request for hearing within 60 days of your reconsideration decision, and I can't stress enough that this is formal court procedure, and CMS will be notified when you file your appeal, and they will assign one of their attorneys from the Office of General Counsel to represent CMS in the case, which is great because then your lawyer has another lawyer that they can talk to and they can discuss the case. And that's a routine thing for us when we file cases at this level. We talk to the attorney on the other side, and generally we are trying to settle cases at this stage because it is extraordinarily hard to win these in litigation. The rules are written to favor CMS, and they have so much discretion when they impose revocations in many instances. And the courts support that, exercise of discretion. So we're often trying to settle cases and get some improvement in the outcome for our client, whether that's shortening a re-enrollment bar, or, in some situations, we're able to convince CMS that they did the wrong thing and they should rescind the revocation. There are other factors we can argue when we're talking settlement, and we can talk about, for example, the impact on patients. We can talk about the availability of services in your particular geographic area. We can argue those softer factors that, frankly, the administrative law judge can't even consider when they're, reviewing a brief and ruling on a case. This is sort of, we often end up at this level, but almost never take cases to hearing. That's not the goal. The goal is often to try to settle the case and achieve a better result for the client. If you lose at the first level ALJ appeal, there is an appellate division. It's a 3-judge panel that will review it. They're going to apply appellate rules. So they're just going to look at whether the judge below, made an error interpreting the law, or that there wasn't substantial evidence to support the government's case. If you lose there, you can go into federal district court in your particular jurisdiction. Again, that's an appellate review. You have to go through all the steps before that and, quote, exhaust your administrative remedies in order to appeal a revocation in federal court. That's an important distinction that you need to be aware of. Let's go to the next slide. This is the last slide. I want to touch on stays of enrollment. I actually haven't had anybody go through this yet. I keep expecting it to happen because there's been a rule out for a little over a year now implementing what's called a stay of enrollment, and it is a tremendous benefit if they'll just please start using it. The stay of enrollment is less burdensome than a deactivation or a revocation. It's a preliminary interim status that's basically a pause in your enrollment. It fortunately does not require like a full initial application as a new provider in order to remove the stay and reactivate your billing privileges. It's available where a contractor has identified that you're non-compliant with at least one Medicare enrollment requirement, and it can be cured simply by submitting an updated change of information form on a CMS 855A or through PACOS. Some examples would include things like failing to report a timely change of address, failing to timely revalidate, or failing to report the deletion of like a managing employee or something. The key points, though, and the advantages of stays of enrollment is you remain enrolled during the stay, they just don't pay you. Claims will be rejected during the stay period. It's never going to be longer than 60 days. It is not considered an adverse legal action, so it's not reportable to anybody. and it can be used multiple times. We have been frustrated over the many, many years I've been doing this when people get revoked for minor things that they just didn't send in a paper enrollment application to update some data point that needed to be updated. This is a way to cure that in a less punitive way. I'm waiting anxiously for Medicare and the contractors like Palmetto to start using this. I haven't really seen stays of enrollment yet, but I'm seriously on the lookout for it. I think that's my last slide. So if there's any questions, I'm happy to stick around and answer those. You've also got our contact information here. You're welcome to email or call if you have any follow-up questions, but we'll stick around for a few minutes. Gio, do we see any questions?
Yeah, there is some, there's two questions. So it says, for affiliation, does this only apply if you are working for two different companies at the same time?
So there's a 5-year look back period. So let's say you have a medical director right now who works for your agency. If he ever in the last 5 years worked at any other healthcare provider that was enrolled in the Medicare program, then you got to look back that 5-year history and gather information about everywhere he worked. I think that answers the question. So it's not just current affiliations. There's a 5-year window you have to look back for those affiliations.
And then it goes on saying it says not two organizations under the same parent company, but different DBA.
Affiliations can be any kind of affiliation. So, if there's a common holding company that owns two companies, and there's, individual owners above that, those could be affiliations. Yes, it can also be, medical director or owner owns a company over here, directly, and owner owns another company over here, and they're not necessarily legally related, but the fact that that same owner owns both companies, 5% or more of each company, could be an affiliation that you have to look at.
Cool. All right. And the second one, it says, how long does it take the CMS to update the Medicare revaluation list? Pulled up our provider number and it shows that it was due February 24th. So should it be concerned that the management did not renew?
If it was February 24th of this year, yes, I would be concerned. And yes, you need to take action immediately. Reach out to your healthcare counsel and discuss it with them. If nothing bad has happened up to now, then chances are you just need to file a revalidation and it'll go through fine. But I suggest you reach out to counsel and have them do a little bit of detective work for you. We did see after COVID, a lot of revalidation dates were moved. They were changed and they weren't super skilled at pushing that information out sometimes. The revalidation database, the link I provided earlier in the slides, is kept up to date. It's supposed to be a reliable source of that information. But I have seen, individual situations where for whatever reason, something got delayed and the provider didn't get notice. But if you haven't revalidated and your date has passed and nothing bad has happened yet, now's the time to act.
Yep, that was the last question. So I'm gonna close out. Thank you so much for our presenters, Jennifer and Christin, for that information, and thank you to our attendees for joining us today. I will be sending out a copy of the PowerPoint slides tomorrow via email. But if you have any other questions, please reach out to Jennifer or Christin to the emails that you see above. Other than that, have a great Tuesday. Thank you, guys.